Good afternoon. My name is Ryan Foltz. I'm a lawyer here at Beresford booth. I've been practicing for 23, going on 24 years now, and my practice primarily involves working with owners and contractors and design professionals in construction disputes. So the bulk of my day is dealing with all sorts of issues and common questions that come up, mostly related to remodels, also new construction, or even the design and the development of projects. Today, I'll be talking about some of the common risks and liabilities that we often see during the course of a residential remodel project. Construction projects rarely go as planned, although we often hope that they will. The goal is always that the project is going to come in on time and on budget. Today, I'll be discussing some of the common disputes and the risks that come up during a common residential construction project that often lead to liability or the exposure of liability. The first thing in any type of construction project that you want to bear in mind is have a good understanding of the scope of work that you're hoping to achieve. Having an idea and a good understanding of what you want to spend, the level of work that you want done will go a long way in reducing future disputes with contractors or material suppliers or other folks. The scope obviously is most likely going to be refined and either expanded or reduced over time. Every construction project has unknowns and issues that come up that you're going to have to respond to on the fly. But having a good idea of what you want done up front is the best way to contain those initial costs and keep the project on track. Don't just hire the first person that you find online to do the work. You're entering a business relationship, which typically is complex. A lot of times it's going to cost a lot of money. And what you want to do is talk to a number of contractors and, if possible, solicit multiple bids. It'll not only give you an idea of the different personalities that you might encounter during construction, but the bids are important to gauge have an understanding of where the market is. Especially in the post-COVID years, we've seen significant variations in costs for materials, for contractors. There's also been a large dip in skilled trades and labor. So talking to contractors, getting a sense of how capable they are and how quickly they can do the work is important to reduce any type of risk down the road in terms of delays or just the timeliness of the work being performed. Once you have a contractor or a couple contractors that you're interested in moving forward with, you want to make sure that the contractor is registered. The state of Washington requires that any type of construction work shall only be performed by a registered contractor with the Department of Labor and Industries. This is information that you can find online, albeit it's not the most easy. It's not easy to find it necessarily when you're looking, but if you know where to go, it's fairly easy to track down this information. And what you'll find with a registered contractor is there are a number of requirements that the state imposes to ensure that homeowners or owners are protected. The first obviously being that the contractor is licensed, but also that the contractor posts a contractor's registration bond, typically in the amount of $12,000, which covers issues or contract disputes or even non-payment of employees that may occur on a job. The other key element is to make sure that this contractor is insured. Most contractors or all contractors are required to carry commercial general liability insurance, the amount of which is typically $1 million per occurrence or per event. That's critical to make sure that there's a level of security with both the bond and the insurance to address any type of damages or claims that might arise related to the contractor's work. It's important to note also that unregistered contractors are not legally entitled to perform work in Washington. And in fact, it's a misdemeanor in the state of Washington if an unregistered contractor is performing work. It's also a per se violation of the Consumer Protection Act if an unregistered contractor enters into contracts and attempts to perform work. And so it gives you defenses as an owner or the folks hiring the contractor that if disputes arise in the future as to amounts due, contract disputes, those sorts of things, those contractors aren't actually permitted to file a lawsuit to attempt to recover the contract balance that they think may be due. The other important aspect of the registration is it bars contractors from recording and enforcing a claim of lien against the property. It's not to say that they won't do it, but an unregistered contractor is not entitled to enforce that claim of lien. So that's an important thing to note also. Once you've located the contractor, you'll be at the stage which is the most important part of the relationship with the contractor, which is negotiating the contract. A well-written contract is the best tool to avoid liability in the future. If disputes arise in a construction setting, the first thing that I'm going to do, if we're representing you as your attorneys, is we'll look to the contract and look at the specific terms and conditions contained in the contract. You'll see a large variety of different variations of types of contracts, ranging from a single page contract to something that may be involved in up to 15 to 20 pages. A lot of that is related to the skill of the contractor, the amount of the project that the contractor is going to be working on, and frankly, whether the contractor is a fairly professional contractor that has been through other projects and understands that the contract documents are critical to ensuring that the work is moving forward as agreed by the parties. Most of the disputes that I see in my practice arise out of the original scope of work and the contract price. The scope of work, it seems simple. It seems obvious that you're hiring a contractor to perform what you talked about initially as the scope of work, but sometimes there are questions, there are vague areas of the work that might not be apparent when you initially start your project. And so if that's not reduced to writing or somehow detailed in your construction agreement, that leads to questions down the road during construction, which usually means that you'll have some type of a payment dispute, or there at a minimum will most likely be an escalation of the construction costs because the contractor, if he didn't have it in his mind when he signed the contract that would be a cost, he's going to add it to the bill during construction or at the end of construction. Some of the things to look for in an agreement proposed by a contractor are certain terms and conditions that might limit your rights against the contractor. A common term that's found in a lot of construction agreements are limitation of liability clauses, which seek to reduce the amount of damages that you can recover from a contractor. So for example, if it's a $500,000 construction project, a contractor might include a term that says the limitation of any liability that the contractor faces shall not exceed $50,000, for example. And even if there was a legitimate claim against the contractor for work that was defective, delayed, or for some other reason, courts will enforce it, in most cases, limitation of liability clauses, even if it appears to be a somewhat inequitable result. The court's going to assume that you've read the contract, and the court's going to assume that you understood that term when you signed the agreement. Another common contract clause to look for is an arbitration clause. Arbitration is intended to be a more efficient and a quicker means of resolving what typically are going to be litigated disputes. There's a limited ability to conduct discovery. The case is usually heard by a single arbitrator who's authorized to issue a binding ruling after hearing all the evidence and arguments and the facts. You don't get a right to a jury with an arbitration clause. And I think one of the more important things is you primarily lose your right to appeal the award by the arbitrator. So you're going to save some time if you go the arbitration route. You definitely will get to resolution quicker, but there are some trade-offs in terms of your legal rights. You should also pay really close attention to the budget and the schedule in a contract. If there isn't a budget, you may just have a fixed sum price for the contract. I would still ask for some type of a detailed breakdown of what the costs are by the contractor, so you have an idea of where these costs are coming from. The schedule is also important to give you an idea, not only when the work is going to be performed, but to give you a date at which you have an idea and an understanding when the work is going to be completed. The cost and timing of the work, it should be detailed as specifically as you can to avoid any type of disputes in the future. Common budget items that you'll look for include design and permit fees, labor, equipment, and material costs, and that will be related to the detailed breakout of costs that I would hope to see in the construction budget. Contractors will also include overhead, profit, and sales tax in the contract. So you may have a sum, which is the cost of construction, the overhead and profit. It's common to see a markup of 20% on top of that typical sub limit of what the cost of construction is. And then, of course, on top of that, you're looking at about typically 10% for sales tax. The schedule is important because it identifies the timing and the sequence of work. So depending on the type of construction project, depending on the extent, you may have some site work that's done, foundation work, other sorts of work that may involve construction from the ground up. If it's a remodel, you may not. So it may be just as simple as identifying when the work is going to commence. But the important part also is to have an idea of the sequencing of the work in the different trades. Most remodels are going to involve multiple trades, such as electricians, plumbers, framers, drywallers, other types of skilled labor is going to come in and do the work. And having an idea of the sequencing is helpful to limit the interruption in your daily life while you're going through a renovation project. Other things that will need to be in the schedule will be inspections by the local building department. And I'll talk about that in a little bit more detail in a few minutes here. But inspection of the work is critical because you want to make sure that your work is properly permitted, inspected, and improved by the local building department. If it's not, that's simply just going to lead to issues down the road once the building department finds out that you've done some work without having the work inspected. Before commencing work, you're going to want to make sure that all the necessary permits have been pulled and are in place before starting the work. One question that will arise or should arise is who's responsible for pulling the permit. If it's a typical building permit, which is a fairly general permit for construction or renovation projects, the owner can pull that permit, or the contractor also can pull the permit, but you'll want to have an idea of who is responsible for doing that. There's a fee that's involved with obtaining the building permit. There's also specialty permits that are required for, depending on the type of work that's being done and the scope and the amount of the work that's being done, but specialty permits include electrical, heating, ventilation, air conditioning, plumbing, and even tree removal, especially in jurisdictions such as Seattle, which are very particular about removal of trees, mature trees. And so there's a number of different elements of the work that you want to make sure the permitting is in place. A lot of times it's specific to the jurisdiction in terms of what's required. So you want to check the local building department's Most of them are fairly informative, and you can jump online and find out what work requires a permit, or you simply could stop by and just give them a phone call and find out. Failing to get a permit or permits for the work can lead to a number of headaches. Building departments, they're not necessarily designed to find and locate jobs that are being performed without permits, but that's not to say that they might not run across your project simply by driving by, or if it's a renovation and a resale of a house, the listing may include additional rooms, bathrooms, other things that a building department could identify and simply just looking at the listings online. And I've seen that on multiple occasions in my practice in the last 12 months, where folks have bought properties, flipped them, didn't pull the permits, and the building department started code enforcement actions against the current owners of the property after the fact. The point here being that unpermitted renovations will most likely at some point lead to liability and the potential for damages. And the part that becomes expensive is if the project involves reframing, structural work, things that involve removing drywall and then putting up new drywall. If you've reframed your property and it does involve some type of alteration to the structural integrity of the house, a building department will come in, make you open up, rip off drywall so they can inspect the work, the framing, the connections, depending on the level of the work. They may also require that you have a structural engineer or an engineer review the work and sign off on the work. Liens recorded by contractors can cloud the title to the property. So a real critical element of any construction project is to obtain lien releases primarily or preferably during the course of construction, but at a minimum at the close of construction, obtaining a lien release, which shows the contractor has released any type of rights it has against the property. Partial lien releases are preferred, and this is a process where typically with each payment, you'll request the contractor also execute and provide a lien release to the extent and for the amount of the work that's been performed to that point in time. At the end of the project, you'll want to get an unconditional final lien release from the contractor, which shows all work has been paid for. There is no claim of lien or lien rights by the contractor. The other important part to consider in obtaining lien release is also requiring the general contractor to obtain similar lien releases from the subcontractors that perform work on the project. You can have situations, unfortunately, where you pay the general contractor for the work to be performed. The invoices have been paid in full, for example, for plumbing and electrical work. And for whatever reason, that money is not distributed by the general contractor to the subcontractors. And if that's the case, those subcontractors also hold lien rights against the property, and they can record liens against the owner. So if you don't get lien releases appropriately and get them also from the subcontractors, you can be in a situation where you may have to pay twice for the same work, once to the general contractor and then the second time directly to the subcontractor to clear that lien. As for timing, liens need to be recorded within 90 days of the last date of work. The contractor also needs to commence a lien foreclosure action within 8 months of recording the lien. If either of these deadlines are not met, the lien is unenforceable on its face and should be released. Simply because a contractor records a lien doesn't mean that it's a good lien. There can be instances where pre-claim notices are not provided, or the work is defective, or there are other reasons why the lien should not be paid because the owner has defenses to the lien. And the lien statute does provide a frivolous lien process where you can quickly get those issues in front of a judge. if you need to in terms of clearing title to the property. The other thing to consider is that attorney's fees are available in lien claims, and that goes both ways. If it is an appropriate lien and money is due and you don't pay it, you could be looking at paying the opposing party's attorney's fees if payment is not made. Liability exposure is a potential for any construction project. I don't want to scare anybody, but there's a number of ways that you can be exposed to liability. What I've been talking about up to this point has primarily been discussing contract damages with the contractor directly. But you also have to bear in mind that there are potential instances where there can be exposure for liability for injuries to workers on the work site or to other third parties. There can also be damage to property, either the project itself or adjacent properties during the course of construction. The best way to minimize liability is to make sure that you have layers of insurance in place. For the contractors, as we discussed, they're required to maintain a CGL policy. You'll also want to make sure and require that the subcontractors also maintain liability insurance. As the owner, you should have property insurance, and that's critical in case there's some type of casualty loss that involves fire, water, or even wind-driven type damages. One little quirk to bear in mind also is that Title 51 is the Industrial Insurance Act in Washington. And under that act, the employers of injured parties are not liable for the injuries. So what happens oftentimes is an injured worker, for example, for a general contractor, is hurt. He can't sue the general contractor, but may look to the owner of the property or the owner of the project as a potential defendant in terms of recovering damages. That waiver or that Title I immunity can be waived by a contractor via his contract. And that's something that the general contractor can also push down to its own subcontractors to also waive that Title 51 immunity. We've discussed a lot of potential problems and issues and liability. Obviously, I'm a lawyer, so I'm going to recommend the engaged counsel, but it's a practical recommendation. If I was hiring a contractor and I had issues that went outside the scope of my practice, I would definitely engage counsel early and often to help me sift through the issues and work through any difficulties that come up during construction. Obviously, for contract review and negotiations, that's money well spent, making sure that your contract is properly in place, that the terms and conditions are appropriate, and that you have good rights and remedies under your contract. Other instances involve disputes with project administration or change orders or simply just payment to the contract that it may be wise to engage counsel to, at a minimum, help you walk through and sift through these issues that are fairly stressful and detailed and commonplace for contractors. So it's often best practice to engage counsel to at least advise you as to what your rights are. Finally, the other issue that counsel obviously would be necessary to engage is if you have a project where there are significant construction defects. These cases involve pre-claim disclosures, and there's a process to notify the contractor. But depending on the level of defects in the type of project, there are projects that simply require active litigation to resolve them, and that's the only route sometimes that an owner can take to get a proper remedy from a contractor performing faulty work. So I hope I've raised and answered some questions, maybe prompted some questions in listening to the webinar. If you have questions, feel free to contact me. My contact information is listed here on the last slide. I also want to plug the other folks in our firm. We have a full service law firm. We do business, real estate work, family law work, and also estate planning. So if you have any questions whatsoever, feel free to email me or simply call our front line, and they will direct you to the attorney that's best suited to handle your questions. Thank you.